Thank you, Mr Speaker. Mr Speaker, before I get into the substance of this bill in the third reading, I'd just like to make a comment about the what the previous speaker just said around the underlying themes of this government. One, and my colleague Clayton Cosgrove touched on this in his speech before me, but I'd just like to say that one of those themes, and we've discussed this quite a bit during the committee stage particularly, is how the instead of boosting jobs and business activity, one of the things that this government will have as its legacy is how it has dragged its heels on making a dodgy business accountable, and otherwise known as white-collar crime. And I do want to make that point. I've got other points to make, but I want to reinforce that point because it is an important point. And I do have some concerns around what Labor is clearly supporting this bill because it's really important that we get it passed into law. But the lack of accountability for the dodgy business practices, and 6 years, it's taken 6 years to get to this point, and this is not the only piece of legislation that this minister has dragged his heels on around these practices, and I think it's important that the public knows that and asks some questions about why that is. I want to go back, Mr Speaker, to talking about the bill as it was reported back from the Select Committee to the House in the second reading, where the Select Committee made these comments around the criminalisation of serious breaches of certain directors' duties, and how we acknowledged as a committee, and it was a hard-working committee, there's no doubt about that, but we acknowledged that we had some dilemmas, and the dilemma was around how to create that balance for criminalising genuine dodgy behaviour and not criminalising legitimate business risk-taking behaviour. We said that we had sought an appropriate balance between encouraging positive entrepreneurial behaviour and imposing clear and effective sanctions on behaviour that crossed a criminal threshold. We said we recommended no changes other than minor drafting amendments to the relevant provisions, but said we would support further consideration of the drafting of these new offences to ensure that those provisions were expressed in a way that provided clear guidance to directors and did not have a chilling effect on legitimate business risk-taking. However, when we got to the committee stage, we had an SOP that did a bit more than that, and I want to return to the comments that my colleague David Parker made during the committee stage, where he expressed some real concerns around possible loophole that this legislation might create. And I'll just reiterate the importance of why we've got this legislation, which is that having limitations on companies with limiting the liability of investors and the amount that they invest, and that the importance of having measures in place that where people put their money at risk, that there are measures in place to ensure accountability. But what we've done, I fear, and I think my colleague David Parker also feared, is that we may have created some loopholes that might result in us returning back to this House. I just want to put this on the record because I wonder whether what we've ended up with, and I also want to note that we didn't return, of course we couldn't return to a select committee process for comment around this, is that what we've ended up with may have been a softening I know the Minister countered that in his responses, but it may have been a softening of the legislation that was returned back to this House. So if we have any members across the House that care to comment on this or have the capacity to comment on this and reassure the House on this tonight, that would be useful, because I don't know what it was that actually made that SOP, that brought that SOP to the House. And I'm just going to quickly go through what it does, because it removes, and this is what we're voting on tonight, and I think everyone should be really clear about that. It removes the so-called reckless trading offence that was in the bill as it came back to the House. It replaces it with a new provision that's based on elements of the duty in section 135, which means that there are accountabilities. The accountabilities are that the director, if the criminal provisions apply, if the director agrees to or causes or allows the business of the company to be carried on in a manner that causes serious loss to one or more of the company's creditors, the director knows that a serious loss will be suffered by one or more of those companies' creditors, etc. One or more of those creditors that suffered the serious loss did not give their prior consent to carrying on the business in that manner. That sounds good. All of that sounds good. All of those provisions sound good. But there are exceptions, and it's the exceptions that worry me. It's the exceptions is that where I fear that we have created a loophole, that there's been a softening of this legislation that may require a return to this House at some point. Those exceptions are where the SOP proposes that directors will not be liable in the following situations. Point 1, they believe on reasonable grounds that all the creditors that will suffer serious loss have been identified, and if they also believe that those creditors have consented to the business being carried on in that manner. The second part is that the carrying on of the business of the company in accordance with a compromise under Part 14, a court-ordered arrangement, amalgamation or compromise under Part 15, an administration under Part 15A, or a deed of company arrangement made under Part 15A. That all sounds very complicated. The problem I have is that none of that, we were not, as members of the Select Committee, we were not given the opportunity to test them. We were not given the opportunity to test the words such as the director believes on reasonable grounds, that all the creditors that will suffer serious loss have been identified, and also believe that those creditors have consented to the business being carried out. This goes to intent. I think criminal provisions that where directors are liable have to be really clear under the law. It's my concern, and I think it was my colleague David Parker's concern also, that there had been some changes brought back to the House that were unable to be tested, and they weren't unable to, not only to be tested by the members of the Select Committee, but also by any other submitters that might have a contrary view or a view that would challenge them. We were also unable to challenge the officials who had provided the wording to us. In this sort of legislation, where it goes to white-collar crime, where there's the ability of directors who have been implicated in these sorts of dodgy schemes, to be really challenged in the court, where they have loopholes to be able to go through, is where we've got problems in our country. We talk about reputation. Reputation is really important, but reputation relies on good, well-founded, well-tested legislation. I've got some concerns about what we've ended up with tonight. I've got real concerns about how long it's taken, and I've got real concerns about that government's commitment to really addressing white-collar crime.
I call Stephen Browning.
Thank you, Mr. Speaker.